Yes, what's happening with this matter today?
Your Honour, before we proceed, I request that I be provided with the name of the counsel appearing in court.
Why's that?
Because it's part of the court record, and under the Open Courts Act, it ought not be concealed from a litigant in the proceeding unless there's a suppression order of some sort.
What's happening with the matter today?
Essentially, Your Honour, this is a malicious prosecution that has gone on for 5 years. I've filed extensive evidence in relation to that.
Yes.
The matter, the VGSO is seeking to withdraw the remaining 2 charges. That application has been resisted by me because the withdrawal comes in the context of the prosecution's non-compliance with 4 court orders for disclosure of material, followed by an application by me that the VGSO be held in contempt of court, which Magistrate Thomas had agreed to hear before His Honour had to unfortunately recuse himself on my application as well. His Honour has made findings of serious prosecutorial misconduct by the VGSO, including deliberate suppression of exculpatory evidence, sadistic. His Honour used either the word sadistic or a similar expression. Suppression of exculpatory evidence in order to undermine the orders of the court and to inflict maximum distress and anxiety on me in relation to the applications that I was making for disclosure of evidence. His Honour found that the VGSO's conduct was similar to the sort of circumstances that are necessary for miscarriages of justice to breed. A recording of the hearing when His Honour found that is in court, and I can play it for Your Honour if required, but it's an admitted fact that the VGSO is not contesting.
So the VGSO want to withdraw the charges,
That's right, and I'm opposing that.
Why?
Because His Honour had commenced determining or commenced the process of hearing me in relation to holding the VGSO in contempt of court for contumacious non-compliance with 4 court orders for disclosure.
If the charges are withdrawn, that would complete the matter and be free to walk away.
Your Honour, under Section 415 of the Criminal Procedure Act, this court is obliged to hear applications from me for instance, perjury. The informant in this matter, after Magistrate Thomas ordered that he provide an affidavit about why he had misrepresented to the court the non-existence of statements that he had collected from key witnesses in the proceeding. He had collected those statements, then suppressed them.
Okay, so Mr. Kuksal, so the VGSO want to withdraw the charges. You don't want them to withdraw the charges. Is that the upshot?
Until the determination.
So no, you don't want them to withdraw charges today?
Until yeah, that's right.
Okay, so what's happening with the matter today then?
So I have...
No,
Your Honour.
Straight after the recusal.
No, Your Honour, that's not what's happening today. I have made a few applications on the last occasion. Those applications were to be listed for a mention today, so they can be put before a different magistrate. The applications are, that's one.
That's right, I've got the application, so you want them to go before a magistrate. How long do you think they need to be listed
May I confirm what applications Your Honour has?
I've got numerous applications before me. I've got...
Your Honour, there's...
You can see how big the file is. I certainly have them there.
May I just confirm it for the recording, because there's been instances where matters have not...
What do you think I've got here?
So, Your Honour should have one application for disclosure of, public disclosure, of the record of the police interview and the video disclosed by the police of the body cam footage of Senior Constables Paul Harrison and Andy Yam. That application is brought under Section 464JB of the Crimes Act. It's an application that I have brought. Then there should be an application that the court find the informant, James Mioch, in contempt of court, or rather that the court enforce the orders previously made on the 11th of August 21, 20th of October 21, 9th of February 23, and 27th of June 23, pursuant to Section 135 of the Magistrates Court Act. There should be an application that this court find Senior Constable James Mioch in contempt of court for contumacious non-compliance with the aforementioned orders, the 4 orders made on the 11th of August 21, 20th of October 21, 9th of February 23, and 27th of June 23.
Okay, so
Section 134 of the Magistrates Court. Yeah.
What am I doing with those applications today? Am I adjourning them to another date for a
You're listing them for a special mention.
Is that so, Madam Prosecutor?
Understood we're in the list to get a date for it to go back for another magistrate because the accused asked Mr. Magistrate Thomas to recuse himself, which he had to do. Now the matters got to be passed to another magistrate.
To hear the applications?
To hear everything that's left.
Your Honour, I need her name as well. For
the Prosecutor, yes, sorry.
And the withdrawal of the charges after that legal.
Okay, so Mr. Kuksal, how long do you anticipate you'll need to argue these applications before a magistrate?
I think, Your Honour, there should be a 2-day mention.
2 days, Madam Prosecutor? 2 days? What's your estimate? Can I have 2 days, please, for Mr. Kuksal's applications? Thank you. I'll take a vote for you.
Sorry, Your Honour, may I please get Your Honour's position in relation to the release of the name of the...
I won't be releasing the name.
And is that because Your Honour does not consider that to be part of the record?
Right.
Thank you. Your Honour, for full disclosure, I should advise this court that I'm simultaneously bringing contempt proceedings against Mr. Mioch for perversion of the course of justice, because in this court, I cannot pursue Mr. Mioch for perversion of the course of contempt of court arising from perversion of the course of justice. So in this court, I'm pursuing him for contempt of court only in relation to non-compliance with court orders pursuant to Section 134 of the Magistrates Court Act. In the other court, I'm pursuing him for perversion of the course of justice, including indirectly through non-compliance with those court orders. But I simply wish to make matters transparent, so it may not, this court may not feel that it wasn't aware of relevant matters.
Thank you, Mr. Kuksal. Let's obtain that. 1st and 2nd of August, is that suitable to you, sir?
If that's the soonest, Your Honour, then
it is, yes. 1st and 2nd of August, suitable to the prosecution?
Sorry, I'm just getting up.
I must also add, Your Honour, there was a cost application as well that was adjourned.
I do have that before me as well.
Thank you.
So that'll go to the same day.
Thank you. And, Your Honour, if I could get an order today for the expeditious release of the recording of today's hearing, just so we have, I read out the applications for the sake of the transcript. And normally if I go through the regular process, it takes substantial time, but if the court orders, like previously magistrates have, for a priority release of the recording, I go through the same process, but it's released a little bit sooner. It'll be required for the Supreme Court proceeding as well. So they know about all the applications that are being heard here, and there's no the concealment of any relevant information.
But what power do I have to order an expeditious release of the transcript?
Section 134 of the Magistrates Court Act. This court has the power to make procedural orders for the efficient conduct of the proceedings and any orders that are in the interest of justice.
Yeah, I'll have a look at that section. How are we going with that date, Madam Prosecutor?
I'm not actually in jurisdiction of those judges, and I'm about to seek counsel in this matter, and I think my instructors would like me to retain it if possible.
What, are you available in July or later in August?
Later in August,
Your Honour,
Sir.
this is her second hearing. Previous counsels have left after they had made misrepresentative statements to the court, for which I'm pursuing them in tort law. She brings no additional value to this matter. This matter has gone on for 5 years. It's one of the oldest matters on the court docket. The VGSO is a model litigant. The court has no obligation to accommodate the availability of counsel. I missed my grandmother's funeral, Your Honour, last year because of the informant's completely unacceptable objection to bail variation.
Mr. Kuksal, I'm going to accommodate counsel this time because counsel's been involved in the matter as soon as possible matters.
And you're not giving me the name of the counsel either. How is this
Okay. I'm just going to stand your matter down while I deal with the custody link.
Thank you.
We're calling the matter of
Shivesh.
We're calling the matter of Shivesh Kuksal.
Thank you, sir.
Your Honour, if Your Honour is to make an order to specifically accommodate the counsel, and the order affects me intimately in relation to the progression of this matter and when my applications can be heard, I have a right to know the name of the counsel. I also have, if I may just complete what I'm saying, sorry.
I'm listening.
Yes. So, Your Honour, there are two aspects to that. The first aspect is the fair hearing rule. I have a right to be provided with all the details, the evidentiary facts in relation to which decisions affecting my rights are made. And secondly, so that is a matter of principle. But secondly, in this matter, there is admitted factual information about the context in which the charges were brought against me. They were brought following a complaint of aggravated assault on me by a PSO. Internal police correspondence has shown that the only reason I was charged was because police realized if I had not charged, the PSO would need to be charged. And through me, there was media pressure on police about whether or not the PSO was being charged. In those circumstances, they brought frivolous charges against me, then added 2 more charges, which they soon withdrew at the middle hearing because they didn't have any evidence to go ahead. And before the matter could be struck out at the middle, they moved it back to the summary stream by withdrawing the indictable charges. Meanwhile, they arbitrarily threw me in jail now and again while my bail application was being heard. I've been subjected to
proceeding.
These are all admitted facts in the matter, Your Honour. They're on evidence. So, in those circumstances, if I am to be delayed any further on the application of a counsel,
Yes.
where previous counsels have admittedly misrepresented the court as to the existence of evidence, I have a right to have my own investigation conducted in relation to whether or not the counsel was in fact busy on the 1st of August. I have evidence discovered, by the way, the court has released that evidence to me, in this proceeding where counsel have deliberately sought adjournments, frivolously, just to prolong the matter.
I'll stop you there. So today, what I'm doing is I'm progressing your matter by setting it down for a 2-day hearing.
And you had initially suggested 1st of August. There was an application made for adjournment.
I've put out a date that's been given to me by the registry.
Which is the 1st of August, the soonest date.
1st of August, that's right, correct, and that date is not suitable to counsel. And I've made a decision.
I don't know her name if she's affecting my rights.
I've made a decision that this particular barrister should remain involved in this matter, and so I'm going to find another date for you.
But Your Honour, Your Honour, may I get the name?
Just a moment, please.
29th
29th
and 30th of
and 30th.
Are they by month, Your Honour?
Is it 29th and 30th of August suitable to you, sir?
Your Honour, I am available on those dates.
29th and 30th suitable to you, sir?
I am available on those dates, but if Your Honour is delaying the matter, it's my...
Well, I'm not delaying the matter. It's a date that's been given by the registry, 29th and 30th of August, and they're the dates I'm going to set the matter now.
Can Your Honour give a ruling so I can have that matter,
What?
my application for the name, because the matter is not being heard on the 1st of August to accommodate the council's...
The name of the prosecutor appearing in court today has no bearing on your applications that will be determined on the 29th and 30th of August.
Your Honour, Section 401 of the Criminal Procedure Act, which relates to costs incurred by parties in the proceedings, contemplates the court's consideration of the timeliness with which the matter is prosecuted. It's my submission that there is a possibility, based on prior conduct, that this council has further delayed the hearing of the matter. Whether or not that application will ultimately succeed is a different matter. I have a right to be heard. That's why I need the name of the council. It's not... Your Honour would understand that if any reasonable person had experienced what I've experienced, they would at least be curious as to whether previous conduct is being repeated. Previous conduct which is admitted, Your Honour, it's not being contested. What I'm saying today would be scandalous if said in court without proper basis. There is authority in COE versus New South Wales Bar Association. It's an authority of the Court of Appeal of New South Wales, which states that when such serious allegations are made against legal practitioners, let alone the executive, then they have an obligation to the court to correct the record on affidavit so as not to undermine the public confidence in the administration of justice. The least this court can do is give me the name of the person who's made an application to the court that this matter not be heard on the 1st of August, which is the soonest availability. And in any event, Your Honour is exercising judicial power that emanates from Chapter 3 of the Constitution of the Commonwealth. Your Honour has to consider what the prejudice is in releasing the name. Why would the name not be released?
There's no need for it.
Your Honour, under Lang versus ABC, that's a High Court authority. It was Lang, L-A-N-G-E, versus Australian Broadcasting Corporation. The High Court held that it is an inalienable right of the citizenry to comment and criticize the functioning of the government, and any impediment to that right is unconstitutional. In Your Honour not releasing the name, what Your Honour is doing is preventing me from criticizing, potentially, the conduct of a government official who has obligations to me pursuant to the Criminal Procedure Act, the Public Prosecution Act, the Victorian Model Litigant Guidelines that are issued pursuant to the Judiciary Act, and a host of other legislation, including the Open Courts Act and the Freedom of Information Act. What Your Honour is doing is expressly contrary to the essence of accountability of government.
Thank you, Mr. Kuksal. Mr. Kuksal, these matters are adjourned to the Melbourne Magistrates Court on the 29th of August 2024 at 10 a.m. The substantive matters that you resist charges, you're remanded to appear at the Melbourne Magistrates Court.
I'm not in bail anymore, Your Honour.
29th of August 2024, and your conditions are extended in the same terms.
Your Honour, I'm not on bail anymore. The bail was discharged at the last hearing by Magistrate.
Prosecutor, are you aware of that?
There was some confusion about it, and so I can't answer one way or another, Your Honour, because...
That's misleading the court, Your Honour. There was an express... I have a copy of the recording.
My friend has just indicated he can check on the court.
The accused full name.
Your Honour, I have a copy of the audio recording. I can pay it for the court, the direction.
No, thank you, sir. It's I'm sure the prosecutor will share the spelling of the name.
Your Honour, she was present, and this is expressly misleading the court.
Sir, please take a seat for a moment and try and finalise the matter. I'm not so I can move on. You can see that before
about
the
the
court.
bail being discharged, but then because Mr. Kuksal
No.
was
Sir, be quiet, please.
various submissions and applications to His Honour who recused himself. I can't remember I cannot recall what the actual outcome of the bail was, but we're just going to check.
I have a copy of the order given to me by the registry which says there has been discharge.
Perhaps you can show the prosecutor. Thank you.
Here. Madam Prosecutor. The anonymous one, here. No, this is professional misconduct.
Thanks,
She's
sir.
required under the bail to be advised of the matter before she appears before the court.
I'm not hearing from you at the moment, sir. I'm waiting for a decision on the bail. Thank you.
There's only one current bail, Your Honour, that was adjourned from a matter on the 20th of the 12th, 2003 to the 25th of March. So that will not be, 2023 to the 25th of March this year, and it's before magistrate review, so it's not this matter. So that would be right that there is no bail on this matter.
No bail. Thank you.
Your Honour, has Your Honour ruled in relation to the application for the expedition release of the audio recording pursuant to Section 134 of the Magistrates Court?
Section 134 of the Magistrates Court Act is something to do with contempt.
Sorry, so 136.
136. Let me have a look at that. Thank you. I'll turn my mind to that in just a moment.
Thank you.
Let me fix this bail issue for you.
Thank you. Would it assist the court if I provided the court with orders made by Your Honour's brothers in relation to the expeditious release?
I'm writing, pursuant to section 136 of the Magistrates Court Act, to order the expeditious release of the recording of today's hearing.
Thank you, Your Honour.
Thank you. That completes the matter. 29 August. Thank you, sir.
Thank you, Your Honour.
Here it is. Thank you, Madam Prosecutor. It is as well. 2 days, yes.
Thank you.
Thank you.